Okay, well, I'd like to welcome everybody to the 20th seminar. I can't believe it's 20. We should have had a party now, man, of the International PhD in Progress seminar series. This is the third phase that's been organised by the Global South Network. And I'd like to start the session by thanking my lovely colleague, Dr. Nauman Rayat, lecturer in law at the Leicester Law School, who's also the founder and convener of the Global South Network. He's the organiser of the PhD in Progress series and previously successfully organised a very highly diverse and inclusive Phase 1 and Phase 2 of the series last year, which my students are already benefiting from, which is fantastic. I'm Diane Levine. I'm Assistant Professor in the School of Criminology, Sociology and Social Policy at the University of Leicester. My own research is focused on understanding the ways in which children and young people survive and thrive when life is very tough, particularly in a digital world and in relation to addressing child abuse, child neglect, maltreatment and child protection. I'm joined by my colleague, Dr. Jing Wang, who is an associate professor at the Leicester Law School. She will be the discussant for today's session, and she specialises in antitrust competition law teaching and research at the university, where she teaches international competition law on the LLM. Prior to joining Leicester, Jing previously worked at the University of Strathclyde in Scotland, lovely, where she taught and researched competition law, contract law and e-commerce. I'm also joined by Muhammet Dervis Mete, I hope I pronounced that correctly as always, who is a third-year doctoral student at the University of Edinburgh. Muhammet's project focuses on constitutional referendums in competitive authoritarian regimes in Latin America, and after completing his LLM at Durham University in 2018, Muhammet pursued another master's degree in the field of public international law at Leiden University in the Netherlands in 2019, funded by the very prestigious and merit-based Jean Monnet scholarship provided by the European Commission. His primary areas of interest include constitutional law, constitutional referendums, constitutional crises, democracy theories, populism and authoritarianism, parliamentary and presidential elections, it's good timing, election law and human rights law. And last but not least, definitely, our guest speaker for today's session is Samuel Gonzalez Catalano, who's a Mexican lawyer and political scientist currently pursuing a juridical sciences doctorate at Yale Law School, where he also obtained his LLM in 2022. He's collaborated at Economia, a prestigious Mexican journal on law and philosophy, and served in several positions at the Mexican Supreme Court and the General Consulate of Mexico in New York. Samuel's research interests include comparative law in Latin America and the Global South, legal and judicial politics, and human rights and democracy. And today, Samuel's going to present on their project entitled Beyond Human Rights Protection, an exploration of the Writ of Amparo as an accountability mechanism in Latin America. So Samuel, you've got 30 to 35 minutes for the presentation. I'll do a wave when we get to the 30-minute point, which will be followed by 5 minutes for comments and questions from our discussant and peer commentator, and 15 minutes of questions and answers from the attendees. So I'll hand over to you now. The floor is yours.
Thank you very much for that introduction, and thank you also to everyone for joining today and listening to me for half an hour. I hope it's not boring, especially when it's a very specific topic about Latin America. So I will try to make it interesting for all of you. So my research focuses on this particular legal proceeding in Latin America called Amparo. The research question, as you can see, it's mainly what is its function. It's a functionalist approach to Amparo. But I think that before going and trying to answer that question, which I will give you a heads up, there is an agreed upon answer among the current scholars in Latin America, and I'm going to try to challenge that and add a little bit of nuance to the question. I think a good first step is to try to explain what is the Writ of Amparo and how does it work in Latin America, because it doesn't work the same everywhere in the world, even though we do have Amparo in other jurisdictions such as Spain or even Philippines. So what is the Writ of Amparo, or the Juicio de Amparo, like we call it in Mexico, or the Juicio de Tutela, like they call it in Colombia, the Mandado de Seguranza in Brazil, or Recurso de Protección in Chile? In the rest 17 countries of Latin America, it's called Amparo. But what is it? So the technical definition would be that it is an inter partes effects judicial review mechanism initiated by any individual to demand the protection of their constitutional rights against any governmental act or even an omission that threatens to jeopardize those constitutional rights. So now, I know this is a very technical definition, and I don't intend for you to grasp the idea of amparo, especially as complicated as it is in the whole Latin America, just with this definition. So let me take a step back again and try to give you a practical conceptualization with some examples. I'm going to try to use the context of the pandemic, which is a very useful one because it was practically a natural occurring experiment that we all experienced in some or another way. And it triggered thousands of amparos to happen in Latin America. So it is a very good example. Let's go back to March 2020 when everything started and focus right now on Argentina. So it was March 2020 and the president issued a series of decrees closing the borders, like it happened everywhere in the world. The objective of this measure was to prevent potentially infected people from coming into Argentina, which is, I suppose, a valid argument for that decree. But it obviously caused a lot of inconveniences for residents, Argentinian residents who happened to be out of the country at the time of the ban. So in the following days after the decree, the country's courts received hundreds of amparo lawsuits by people who claimed that the decree was violating their residence and free transit rights. As a result, the country's foreign ministry had to suspend the decree, even before the courts were able to rule on them, because everything was happening very quickly and everybody was shutting down. So the foreign ministry suspended the decree and made significant efforts to repatriate the nationals stranded abroad. So amparo worked in this case, and it helped to protect the rights of those people stranded abroad. Another example, Colombia, also March 2020, the president issued a mandatory isolation order, mandating the vast of the population to stay at home. During this period, one group of people that was particularly affected was the homeless people, because they did not have a space to comply with isolation, and also because they didn't have the resources to live for a prolonged time without income. So a group of people in this situation filed amparo lawsuits. In Colombia, it's called tutela lawsuits against the government, arguing that the measure ordered by the executive, the isolation order, was not taking into account the right to health and the right to adequate living conditions. And as a result, a few days later, the Colombian Constitutional Court ordered the government to provide the homeless population with shelter and with the necessary resources to comply with the isolation policy. Now, I want to make a clarification, not the entire homeless population, only those who filed the tutela, because that's how it works. It only has inter partes effects. It doesn't have erga omnes effects for everyone. So it's a point to consider. A few months later, in Brazil, July 2020, the government ordered the workers at Banco do Brasil, which is a government-owned financial institution, to return to their in-person activities without exception. So this is only 3 or 4 months after the pandemic started, so it was quite soon for them to be ordered to go back to in-person activities. And it was still quite risky, as I'm sure you can remember. So the Banks Union filed a mandato de segurança, which is an amparo in Brazil, on behalf of the workers, arguing that this measure affected their right to health and their right to work safely. So the court in charge of the case decided that Banco do Brasil had to respect their employees' right to continue working from home until the conditions of the pandemic in the country allowed to ensure their right to health and life. Let's take a step forward and think of the beginning of 2021, when the first COVID vaccines got approved, and all of us were very enthusiastic about it. And governments started creating vaccinations plans, trying to give priority to first-line respondents and some high-risk groups of people. And in Chile, dozens of people filed acciones de protección, or amparo actions, asking the courts to move them up the line in the vaccination program because of their age, because of their profession, or because of their health conditions. They needed it to be protected, their right to health to be protected. So courts ruled in favor in some cases when they saw merit in the case, and in some other cases, they agreed with the state's vaccination plan. Another big leap to August 2023, in just a few months ago, the Argentinian Congress passed Law 27.491, ordering mandatory vaccination for children, not only for against COVID, but against many other diseases, COVID included. And many parents filed amparo lawsuits arguing that this law in particular was against their right to choose and could even violate the right to health of their children. A few months later, Argentinian Supreme Court ruled against in most cases and validated thus the state's vaccination plan and the state's obligation for everyone to be vaccinated, for every children to be vaccinated. And just to finish this series of examples that I hope are useful to try and understand how amparo works. I like to call it the wildcard lawsuit in Latin America because we use it for everything. But in Mexico in 2023, a group of people filed criminal charges against a man called Hugo Lopez Gatell. He was a person in charge of the country's strategy against COVID. So they filed criminal charges accusing him of criminal negligence because there were a lot of excess deaths during the whole phase of the pandemic. And the federal prosecutor denied to start an investigation against him and was later validated by a criminal judge who issued a ruling validating the no investigation. So that same group of people filed an amparo, arguing that the prosecutor's decision not to investigate the crime was denying them their access to justice right. And thus, a few months later, a federal court granted the amparo to this group of people, and the prosecutor's office had to start an investigation against that man, even though in the end it led to nothing. So it was an interesting case. So can we go to the next slide, please? Let's try to make a recount of everything. I hope it wasn't overwhelming. So what is the Juicio de Amparo? What is the Writ of Amparo? It is a constitutional legal proceeding. As you can see, it is not part of the ordinary justice procedures. For those of you who are from civil law countries or are familiar with how civil law countries work, the amparo doesn't belong necessarily to administrative justice or civil justice or criminal justice or laboral justice, as you may think from the examples I just gave you. It is directly a constitutional legal proceeding. So in most cases, you go in front of some of the highest courts in the country, federal courts, or even the constitutional courts, when you file an amparo. Now, who are the parties? The petitioner is necessarily an individual, anyone. It can even be an underage children, or it can be a person with a disability as long as they have some representative. But everyone in the country can be a petitioner of Writ of Amparo. The respondent, in most cases, is necessarily an authority of the government. It can be part of the executive branch, of the legislative branch. It can be part of the judicial branch. You can file an amparo against a court ruling. And you can even file an amparo against independent agencies in their own capacity. If they issue a ruling of if they take a decision, you can file an amparo against that. And the claim, obviously, as maybe you saw, it's that that particular authority is violating the rights of the petitioner, the constitutional rights or the human rights. You may see that I'm using those terms indistinctly, and that's because in Latin America they mean the same. human rights and constitutional rights and fundamental rights are the same. They are those who are in the Constitution, or maybe even those who are in international treaties that the country has signed and ratified. So that's what constitutional human rights mean when I'm talking about them. So now there are some similarities between this and habeas corpus that exist in some other jurisdictions, but the big difference is that habeas corpus only works in criminal investigations or in criminal cases, and amparo, as you can see, works with everything. It doesn't matter. And also another similarity that you may find with your own jurisdiction is that amparo, before being granted or before being done, before the procedure even starts, the court can grant a provisional or permanent injunction to try and safeguard the status quo, the rights of the persons involved before a full decision. Another characteristic of amparo is that it has inter partes or limited effects. This means that only the person who filed an amparo can be benefited from the court ruling. This has had some recent developments in recent years because especially with environmental rights and social and cultural rights, courts have been noticing that you cannot grant a right only to one person. So in some cases, there has been some flexibility about this limitation, but it varies from country to country and also from case to case. So it is still a little bit different among jurisdictions. Now, as you can see, and as I've been trying to repeat, everything revolves around human or constitutional rights. And thus, understandably, when asking the research question that I'm asking, which is what is the function of the Writ of Amparo in the Latin American legal systems, the most obvious answer is that the function is to protect human rights. Because it is true, Amparo is one of the leading legal tools for human rights protection. Can we go to the next slide, Norman, please? Thank you. And some examples of this that you may see can be found on these pictures that are very interesting. Many of the conquerors of Amparo or the victories of Amparos and human rights can be found, for example, in abortion rights. Now, as you can see in the first picture, it's a protest of women in front of the Supreme Court Justice of Mexico, fighting for their right to abortion, because at that moment there was an abortion case being decided by the justices. And at the same time, another day, this is fun because I was working at the Supreme Court at that time, and we had to go through the back entrance. A group of people started praying in front of the Supreme Court for the justices to rule against abortion. So it was very interesting in that particular case. And the next one, please. Another great victory of amparos, or tutela in this case, because it was in Colombia, is euthanasia. I hope I'm saying it right in English. I haven't ever said euthanasia in English. But it is a right that was also granted via an amparo in Colombia. This is, for example, one of the first cases of euthanasia being performed in Colombia, the case of Marta Sepúlveda, who was denied the right to mercy killing by the Colombian authorities, and was she later filed a tutela action, and it was granted by the Constitutional Court of Colombia, and she eventually went through with the euthanasia herself. So it was an interesting case also. Next slide, please. And also environmental rights. I know the slide's in Spanish, but Peru is one of the countries who has gone through with protecting many environmental rights through Amparo. They have done a very interesting job about it. They have given general effects to Amparos in some cases. So that is a very interesting case. And any other right that you can think that exists in the Latin American Constitution, I assure you there is precedent in the constitutional courts or in the federal courts about it. Indigenous rights, the right to use drugs, environmental rights, any number of rights that you can think of, they have been protected systematically with amparos. So by now, I hope I was able to explain or maybe give you a hint of how amparo works in Latin America. Next slide, please. Now, this is where my hypothesis comes, and I'm going to try to persuade you about it. And please let me know if I was able to do it, or if you have any doubts about it, because I'm going to try to make it as persuasive as possible. So the question that I ask myself is if it is true that human rights protection is the one and only function of amparo. Because from the current scholarship in Latin America, that's what it seems to be. It's the main function, and it is what it is for. However, I think that in order to complete the puzzle of what is the function of amparo, there may be another pieces missing. And one of those pieces, I think the most important ones, is the one I'm going to try to present, which is that amparo also works as an accountability mechanism in the whole democratic life in Latin American countries. So this is not something that I'm inventing. This is not something, I'm not trying to find something absolutely new, of course. Political scientists have talked for a long time about strategic litigation as an accountability mechanism. So this is kind of the picture that you see here. Voters and parties can try to exercise vertical accountability mechanisms against the government, in many cases using the courts. Also, the media and civil society organizations can also try to exercise diagonal accountability mechanisms against the government. And even in some cases, of course, the oversight bodies or other branches of government can exercise horizontal accountability mechanisms. But that's not something that I'm going to talk about. I'm focusing mostly on individuals, voters, political parties, the media, and civil society, who are also members of the society who exercise accountability. Next slide, please. So now, specifically about amparo as accountability, it is also not my my idea. It's something that political scientists have mentioned before, especially during the third wave of democratization in Latin America. There were a lot of political scientists who focused on accountability mechanisms, and they talked about formal and informal mechanisms of accountability, about protest, about these kinds of writs of amparo. And in many papers and in many books, you can find that they say that amparo is going to be a very effective mechanism of accountability. And that's what they say. And that's it. Because after that, the Latin American scholarships came and they focused on human rights, because it is a very important topic. I don't deny it. It is a very big part of the explanation of what is the function of amparo. But I think there might be something else. So recently, this idea was also mentioned by this Mexican scholar called Ana Fierro, who briefly in a paper mentioned that amparo is the most powerful accountability mechanism in the Mexican legal system, because it does allow individuals to challenge any public decision regardless of the level or branch of government by which it was undertaken. And finally, it was mentioned by a recent paper by Edgar Melgar and Susan Rose Ackerman, who mentioned that new developments in the use of amparo in a few countries suggest that it could develop into a mechanism for civil society to obtain some procedural reforms that increase public participation in public choices that arguably violate collective rights. So this is not a new thing that I'm inventing. It was already said, but I'm going to try to specify what mechanisms people use in order to exercise accountability through amparo lawsuits. So next slide, please. I know there are some challenges to this research hypothesis. I'm not gonna try to solve them, because I don't think it is my place. I'm gonna try to explain why. One of the main challenges is that people, in order to be able to use amparo as an accountability mechanisms, they are going to have to use the human rights language. Why? Because the only way a court is going to accept an amparo proceeding is if it involves human rights. So you're going to have to be able to use human rights language in your lawsuit in order to be successful. Another barriers that you might find is, of course, the cost benefit. A lot of people are not going to be able because they don't have the time or the money for paid for lawyers. So especially when you are getting very little compensation with an inter partes effects lawsuit. Also, another barrier can be judicial intervention, because judges and justices can have their own agenda, and it might be different from the agenda of the people that are filing the lawsuit or the amparo. So that's another barrier. Another one is, of course, the lawyers. They also have their own agenda, and they might be able or more open to accept some cases and not other ones. And finally, I call it the Rosenberg's dilemma. I don't know if many of you are familiar with his book, The Hollow Hope, in 1991. But essentially, the main thesis is that court rulings cannot create real change, and that change only happens when it comes from the legislative. So this was a very unpopular book back in 1991, but his ideas have been becoming more popular as a more conservative court in the US has been present, particularly after Roe versus Wade was taken back. So he might have some point. And it affects the idea of amparo accountability, because you are not, if this is all absolutely true, then even if you get a good result with an amparo and exercise some kind of accountability, well, you're not creating a really good change, a really permanent change, because it can be taken back at any point. And the real change should be focused on convincing the legislative to change the laws. I suppose that would be the argument. So it is certainly not perfect. The idea of amparo as accountability. Accountability is not a perfect accountability mechanism, amparo. However, people do use it like an accountability mechanism. That's what I'm trying to say. Why they use it as an accountability mechanism? That's a good question. Not exactly the topic of the paper, but the paper I mentioned before by Melgar and Rose Ackerman does provide some kind of an answer, which is that there are no other good mechanisms of accountability in Latin America. There is not an administrative procedure like in the US or in Europe. There are not many overseeing bodies. So amparo is what people have, and that's what they use. I guess that's what they say. So now I'm gonna try in one of the last. I think the slides are gone. Okay, in one of the last slides, I'm gonna try to convince you lastly about the preliminary findings. So these are the ways that I found out by reading many court cases that people are using amparo as an accountability mechanism. So one of them is to directly influence public policy implementation. There have been many Colombian tutelas that have been trying to convince the courts to include more medications to be free of charge into the public health system, and they have been successful. So there are many books about this, and there's a good paper by Cesar Rodriguez Garavito talking about how a series of tutela actions have been successful in changing the public health system in Colombia by convincing the authorities into including more drugs and more kinds of sickness into the free health system. Another way in which amparos have influenced public policy implementation, and this is all over Latin America, is by forcing the authorities to adapt particular public policies to indigenous customs. Another way in which amparo is used as an accountability mechanism is to demand the construction of public infrastructure, or even to demand the authorities to stop constructing public infrastructure, to stop building public infrastructure. One of the most famous cases is the resistance to hydroelectric plants construction in the Amazon, which is a still going battle. And also another that happens all over Latin America is the battle for accessible infrastructure for people with disabilities. Now remember, all this has to be framed into the human rights language. So obviously they claim environmental rights in the case of the hydroelectric plants, and they are claiming right to health and right to equality in the case of the accessible infrastructure for people with disabilities. Another way in which Amparo is being used as an accountability mechanism is to demand transparency in public decision making. There have been many interesting cases about this in Latin America recently, and especially in Mexico. That's where I'm from, because we have a very popular president who has very ambitious ideas about building infrastructure. But he gave the order for the army in Mexico to build all this public infrastructure. And in order to make it very fast and very efficient, they claimed that all the information regarding these projects was of national security and thus was secret for 10 years. So there have been lots of amparos, I dare to say hundreds and even thousands of amparos, trying for the president and for the army to disclose all this information about the projects, because there might be a lot of corruption happening, there might not, but we don't know because all that information is secret. It's a very interesting case. Another way in which it is used as a mechanism of accountability is to express support or rejection towards a particular government official. So this is also a very interesting topic, and it has very kind of fun cases. One of them is the one I mentioned during the pandemic against this particular public servant, Hugo López-Gatell, who was in charge of the pandemic in Mexico, who was criminally investigated, even though it led to nothing. But he was criminally investigated via an amparo. And another case, very interesting, you might know President of Colombia, Gustavo Petro. Back in 2014, he was investigated because of some irregularities in a particular public policy that he was implementing in Bogota. He was Bogota's mayor, and he was found guilty, and he was given some kind of sanction. Not a big one. He was not put into jail, but he was given an administrative sanction. And a lot of people starting filing tutelas. They even called for people to start filing tutelas. They called it a tutelaton. So dozens of people filed tutelas supporting Gustavo Petro. The Constitutional Court of Colombia disregarded all of them. But this is an interesting case because it catches the media attention, not only in Colombia, but in many countries around the globe. And you may say it is a case of winning by losing, because they did get what they wanted, which was attention. Which leads me to the next way in which amparo can be an accountability mechanism, which is to cause media attention to a particular government decision. Sometimes, like I said, winning by losing. There is a lot of information about it also in Latin America. There is this idea called parallel courts, which is that you are following two kinds of trials: the trial between the formal courts and the trial in front of the public opinion, which is an interesting case. And Chile is one good example about this. Before they agreed to change the constitution, there were many lawsuits filed only to make a parade, because courts in Chile are still very conservative. So people knew they were going to lose the cases against the government, but they still filed them in order to call the media's attention about it. And last but not least, another way in which I have found amparo to work as an accountability mechanism is to create a last resource mechanism, providing a de facto right to a third instance. So you can also file an amparo against a court ruling. So in many cases, you can find that local courts, for example, are very conservative, but federal courts, which are the ones in charge of amparo, they are very progressive. So in many countries, I give you one example from Mexico because it's the one I know best, but I have a list of cases from other countries as well. In the case of the use of weed, legal use of weed, many states were very conservative about it, and they were still prosecuting people for having weed and for smoking weed. And what people did was file amparos, and the federal courts in Mexico and the Constitutional Court in Mexico granted them the amparos because they considered a part of their right to choose their way of living, which is a very weird thing to say because it's not a right that is in fact in the Constitution, but the Supreme Court in Mexico went creative on that one, and they granted them amparo. So from then on, people who wanted to be able to smoke weed legally, they have to go through all the proceedings. They have to start by being detained or by asking an authority to smoke weed. Then the state authority would say no. They would have to file a lawsuit against that. The state court would say again no, and then they would be able to file an amparo, and the federal courts would be giving them the permission to smoke weed. So it was a very interesting case also. Final slide, please, Norman. And just to finish, these are some questions that I have about the project, which is still in a very early stage, and I want your opinion about this. Particularly in first place about the case selection, I come from a political science background, and sometimes comparative political scientists are very strict about this, about the selection of cases. So I might be putting myself into too much trouble, but I don't know if I should make a case for why I'm choosing some countries and why I'm leaving some others behind, even though I can find cases about it, but I don't think I can I can put all of them in one paper. It could be a very long paper. Also, I could try to make the case selection by a time frame or by finding very paradigmatic cases, I suppose. Another question that I have is if I should focus on one only kind of accountability, only in administrative accountability, because as maybe you saw, Amparo can also perform legislative accountability or judicial accountability. So it would be interesting to hear your thoughts about it, because it might be easier to focus only on one kind of accountability. And if I'm being truthful. And last but not least, the proposed structure of the article right now is to first, in the introduction, explain the research question. In the first section, to briefly describe the Writ of Amparo's origin, which is back in the 1800s, the similarities and differences among Latin American countries, which is something that has been done. So I'm not worried about it. I just have to do the work of trying to summarize the work that has already been done. The second section would be to present the academic status quo, which is Amparo works for protection of human rights. So there is a lot of work about it as well. I'm not worried about it. The third section would be to present my paper's thesis, which is where I start to have some trouble. That I hope I was convincing enough to you all, and I hope I can show that in the paper. And finally, the last section would depict these particular ways in which I have found that Amparo can work as a mechanism of accountability, which could include a series of case studies. So that's my idea right now for the paper. But I would like to hear what you think about it. Maybe I can just eliminate the first section because that's something that has been written about. But also, if I'm trying to reach an audience of English-speaking people, it might be necessary to give some context about what is Amparo and how it works. So I don't know. I would like to hear your feedback. Thank you very much.
Thank you, Samuel. You are spot on time-wise, so congratulations for that. I'm going to invite Dr. Jing Wang to now act as our discussant, but I just wanted to say, as the chair, you apologise a lot for your work, Samuel, and actually your passion, your commitment, your clarity of thought around it as a non-expert come across really well. So you can feel confident that the way that you're communicating these kind of quite big ideas, particularly to a lay audience in my personal case, it's very clear. So, I hope you can kind of draw some confidence from that, because, yeah, I mean, I'm totally fascinated. Okay, sorry, Jin, I'll hand over to you now.
No problem. Thank you so much for that. And thank you for this fascinating presentation. I definitely agree about your confidence level. So I saw how much work has already been done to put into, and how rich the resources you already collected and actually understand them well. And collecting things together, we can understand. I'm not a human rights lawyer, I'm not a constitutional lawyer, but I understand it with no problem. So yes, be confident, please. And you actually very well spot your own challenge, which is the majority of my questions are actually drawn around. Okay, so you know exactly what you're doing, which is a great for PhD students at this stage. So I think instead of asking a question, I probably just answer your question, because we're actually focusing on the same thing. I guess it's quite a lot that you would like to put into your thesis. However, the thesis is just a very limited words and limited length. We all know that, and limited time frame. So it's probably not a very good idea to including everything. So you mentioned Colombia, Brazil, Chile, so they were already different jurisdictions you mentioned for a reason, but I would suggest you to focus on one or two. And that probably easier. And draw comparative studies whenever necessary, but rather than try to cover everything. I know there are certain countries having this, but you don't need to cover them all, and that can be for your future research. And I guess the other question you were asking about which perspective of human rights you're actually going to look at, because you have already drawn 6 findings, and they are really helpful. But are you going to include them all? This is something I would like you to think about.
Okay.
Yeah, so don't need to answer, it's just think about it. And then that can follow up with the following question is, if you are not going to cover all of those 6 findings, then it's probably just link you to the next question about how many cases you're going to include, because it's very clear from your presentation, each finding connect to certain type of cases and connect to certain countries. So maybe that's where your restructure of your thesis or narrow down your thesis, the border of your thesis could start with. And also, yeah, sorry.
I was just going to ask a clarifying question, and perhaps this is the fact that you're based in another country somewhere might be where my confusion is lying. Are you preparing this work for kind of a journal article publication, or is this, when you talk about the structure, are you thinking about the structure of the full thesis?
Right now, I'm thinking about publishing as a law review article. Many doctoral programs in the US have this opportunity for you to, instead of working on one whole dissertation, to divide it into 3 articles. So
Right.
that would be the idea.
Yeah, so we call that a PhD by publication. Is that the sort of idea? Okay, forgive me, that is just a clarification from my point.
That's great, because I somehow getting confused between the terminologies being used for thesis, paper, and article.
Me too. I think Jing's point then is absolutely opposite about, limiting for one article. I think you're definitely going to need to kind of limit down.
Yeah, because I think it's probably an idea if you are mentioning about you're going to thinking about publishing 3 articles, maybe each article going to focus on one of the findings you actually represented to us. Otherwise, it would be too big. Even though American publish really long articles, but it's still going to be big, because each case is going to cost you some discussion. And also the other thing is you're also going to expand your discussion based on those cases. So my following question is, when you mentioned there are successful cases in different areas about public policy or challenging the implementation of things or public decision, so is that a lead to the changes of policy or the changes of the implementation? Is there anything happening after the case being successful?
Yes, there have been many successful cases.
No, I mean, the case is being successful, but has the successful decision of those cases influenced the policy changing afterwards? This might be something you would like to follow up.
Yeah.
Yeah. So this is
yeah.
And I guess the other question I have is really about methodology. You didn't mention that, but I wonder, have you done or planning to do any interviews with those judges who actually making those cases, or with the plaintiffs who actually start to get the law case moving?
Yeah, right now my answer for this paper would be no, but I have been planning the rest of the papers, and I would like to do one with interviews with civil society organizations, with lawyers, and even with petitioners of big amparo cases. So that is in the background. That's an idea that I have, but not for this particular paper, because it would be too much to include interviews.
Yeah, and it could delay the process as well. But I think my question about interviews probably is more about the entire thesis rather than about this particular paper, because I think what you're doing at the moment about case law is already very rich. And I guess my last question really is about a comment is, when I read your abstract, I just thinking about EU law. I know it's not the same structure, but I'm just thinking, one of the very interesting feature of EU law is individuals, citizens would be able to challenge their state. And there is a supranational court in the EU to actually support them with this. So I just wondering, is there any possibility that this kind of comparative can be drawn into your research?
Yeah, I think it is. The EU law is very similar to what I'm talking about, and I usually think more about the Inter-American Court and the Inter-American system, because they did copy the Amparo proceeding. The Amparo proceeding is an idea that comes back from the Cadiz Constitution in Spain, and it was retaken by the Yucatan Constitution in Mexico in 1841. It was later more developed in the Mexican Constitution in 1848. So this is not a new idea, and the Inter-American system has used the idea of an amparo internationally. So it could be interesting to do a comparative work about it. I don't know if I would be.
This again, not for this article you are talking in particular, but maybe for your entire thesis, or even probably just an idea for the future research.
Yeah, no, undeniably it is an interesting idea.
There
are other complications. For example, the cases in the American court take many years, 5 to 10 years. So I'm not sure if accountability is very effective if it takes that long, but it is an interesting idea to think about.
I'm going to be very rude and interrupt and just invite Muhammet to please contribute, if that would be okay. Just I can see we're going to start running out of time. So, but yeah, fascinating. Muhammet.
Thank you, Diana, and thank you, Samuel. It's quite, I think, clear and straightforward project. And I think this project has unique aspects. As you say, before I came here, I checked the literature, and as you point out, almost every scholar is just touching upon this issue, writ of amparo, from the perspective of human rights protection. That's why I believe that this is unique and this will contribute to the literature a lot. But as you know, the human rights protection is a very broad and overarching concept. It's a very broad church. And also in your preliminary findings, you divide and categorize this mechanism. And you said it might function like it might directly influence public decision-making, demand transparency, decision-making implementations, and gain attention of media. That's why I think it's either directly or indirectly related to decision-making process. The point that I want to make is, as you know, currently all the constitutional scholars is focusing on how decision-making can be more deliberative and participative. So, and it's also very broad church, you know, that even we have a deliberative democratic theory journal. Its name is Deliberative Democratic Theory. So maybe you might consider how Amparo, how this mechanism might contribution a meaningful deliberate, how we can combine these two interrelated concepts and how this mechanism contribute to the meaningful and effective decision making. I think this is quite important. You might consider this as an option. Another thing is that I want to make is yeah, and also I would like to suggest one reference to you. I had the opportunity to read a manuscript, the entire manuscript of former Minister of Foreign Affairs of Peru, and he's also former President of Constitutional Court, is Cesar Landa Arroyo. I had the opportunity to read the entire text because he just asked me in Baghdad in a conference if I can read the entire text and provide my feedback. And his book will be published in Cambridge within a couple of weeks. So you will have the chance to read this book because almost 30 or 40% of this book is directly related to Writ of Amparo. How it's functioning, if it's effective or not, how it can be more, you know, be more effective, and mostly from the perspective of human rights protection, but still I believe that there are lots of fruitful discussion on that paper. And finally, in terms of methodology, when I look at my notes, this is quite similar to Dr. Jing's comments. I just realized that maybe you can adopt like most similar approach, you know, there are lots of methodology in the literature you can adopt. And I think you just need to stay away from some kind of arbitrary pick and choice, arbitrary decision. I like this country, I don't, this is quite dangerous. And maybe this is the most difficult part of, you know, deciding which countries you need to pick and choose, because you need to justify. And you can also, I think 1 or 3, maybe maximum 3 is enough for this selection. And you might also think about which one is successful, which one is unsuccessful. I mean, you can pick and choose one successful and effective, and the other one is unsuccessful, and you can explain why it's effective, but why the other is not effective. And this is my notes for now. And thank you for this amazing presentation. You are doing a great job.
Thank you, Muhammet. That's very, very useful. I think we have time for one question, and Sonia got her hand up first. So I'm going to invite you, Sonia, to unmute and share your question, please.
Great, thank you. Thank you so much for your presentation. I'm sorry I was a bit late, so you might have, I don't know, answered my question already in the first part of your presentation. But I'm interested in your selection of I guess the terms accountability or accountability mechanism as a focus of your research, as I guess like as the alternative to constitutional rights protection. from what you were saying, many of the examples that you were giving, yes, I did see the appeal of talking about accountability mechanism, and I think I would support that decision. But I did wonder why you chose those terms instead of talking about something like upholding maybe checks and balances more generally, or maybe upholding the rule of law as such. Maybe I think what I was lacking from your presentation is what exactly really you mean by accountability. I'm
going to interrupt, Sonia. I'm so sorry. Yeah. It's just that Samuel only has 2 minutes to respond, so I'm going to just give him a chance to kind of touch
That's the question.
That. I know how strict Nauman is about. Right, now we're finished.
Yes, thank you, Levine, and also thank you to Sonia and Muhammet and to Jing for their questions. I think they are all very interesting and something that I have to think about. Just answering really quickly to Sonia, I think I wanted to take the perspective of the citizen and not of authorities, because usually when you think of check and balances, you think of the judiciary, or you think of the legislative, or the three branches of government, or even think about independent agencies. But I was thinking more from the perspective of the citizen. But I agree, I need to give a good clarification about this and provide a good, or at least some kind of definition of accountability. And also to Muhammad, thank you for your recommendation about Cesar Landa's book. I've read some articles from him, and they are very interesting. So I look forward to read that book. And it was also very interesting to think about deliberative public decision. I think it could be interesting to include that in the paper. I haven't thought about it, and I think it would be a good idea to make it more publishable. And also for the recommendations to stay away from arbitrary decisions in picking the countries. So I think this was a very, very useful space to share my ideas. I hope it was interesting to you all, and it will be very, very useful to me to include all your comments. Thank you.
Thank you so much, Samuel. I think we've all had a super interesting afternoon, and we look forward to seeing you next week when our guest speaker will be Rashida Abdul Hamid, who's a PhD candidate in the Faculty of Law, University of Cambridge, St Catherine's College, who will present their project titled The Defective Deployment of the Basic Structure Doctrine in Malaysia. Well done, everybody. Enjoy the rest of your afternoon.
Thank you.
Thank you. Bye.
Bye.
Thank you.